Good afternoon, everybody. Thank you so much for joining us for today's webinar, which is the third in a series on virtual proceedings in the New York State and federal courts. My name is Elizabeth Stong. I'm a bankruptcy judge in the Eastern District of New York, sitting here in Brooklyn. I'm coming to you live from my chambers, where I am thrilled to be moderating a program that is going to bring together a lot of what we've discussed in our first two programs and see what we can really synthesize and reflect on and look forward to in lessons learned and next steps, virtual proceedings in the New York State and federal courts. This is our third of three, our roundtable on best practices, brought to you by a long list of New York City bar committees, one of which is the Council on the Profession, many others of which are represented on this program today, and all of which are really dedicated to the idea that we need to bring together the very best resources of the bench and the bar and the organized bar to be sure that we're not missing an opportunity to do the best possible work we can for the justice system, for our clients, for the people who appear in front of us, and for our communities, regardless of whether there's a pandemic, but maybe especially when our systems are so taxed as they are these days, when there is the kind of unprecedented situation that we've all been navigating for a little more than a year. We have a fantastic group to hear from on this topic. First, I'm just going to try to take these alphabetically. It's the only way to prioritize. Otherwise, if I told you my favorites, I'd have to do everyone first. Justice Elise, Supervising Judge of New York County Civil Court. Jason Canales of Canales PLLC. The Honorable Sarah Kay, the United States Magistrate Judge for the Eastern District of New York. I'm going to ask you to wave as I say your name and position. The Honorable Joel Cohen, Justice of the Supreme Court of the State of New York County Commercial Division. We'll point out Acting Supreme, a judge also of the New York Court of Claims. Elizabeth, known just as Liz to anyone who's known her for more than an hour, I think. Liz Donahue of Himmelstein, McConnell, Gribben, Donahue, and Joseph. Sarah Wagner, the Associate Director of Teamsters Local 237 Legal Services Plan, and Lorna Jen, the Supervising Attorney of the Domestic Violence Unit of New York Legal Assistance Group, or NILAG, and me, your humble moderator. So we're going to dive in with a lightning round of questions, quick questions to hear from each of our panelists. We'll go in alphabetical order, first the bench, then the bar. And here's the question. What stands out from last year's pivot, just about a year ago right now, from business as usual in our court systems and offices to remote proceedings? Positive, it can be negative, it can be a surprise. What stands out? Justice Ali, let's begin with you. And thank you again for joining us.
Well, thank you. Thank you, Judge Stong, for your role as moderator. Certainly not an easy job, but for some reason you just make it look effortless. So you definitely have a career outside the bench as a professional moderator. And a warm greetings to my fellow panelists. It's an honor to be on this panel with all of you. I've heard you all speak, and I take copious notes when you speak. So if and I will again today. So thank you. What surprised me is this: the pivot. That's exactly the perfect word. You know, on March 15th, I was sitting in a Bronx criminal court in a very high volume practice, handling cases. And the cases in criminal court were very paper intensive. They were files. They would hand you a file, you would, the bridge officer hand you a file, you would write on it very quickly and then hand it back. And then the pandemic hit and we went virtual. It's amazing to me in 12 months, in 1 year, how quickly we got it right. And got it right means this: how quickly we were able to still do the administration of the court without sacrificing the work and sacrificing the safety to the public. Just the other day, and I know it's a lightning round, so I'll wind up very quickly. Just the other day, I was speaking to a litigant, and then I always say the same thing to the litigant: I'll see you in the next court date. Hopefully we'll be back together again. And the litigant says to me, well, do I have to? And I looked up and I said, well, what do you mean? The litigant said, this virtual appearance works very well for me, Judge. I don't have to take a day off of court. I can call you during my break. Do I have to come see you? And I said, well, half of me is offended. The other half gets it. So when we talk about resumption of proceedings, resumption for who? What's our normal? And we all have to come together collectively, everyone on this call, everyone working in the court system, to come up with a definition of the new normal. I'm all in. I'm happy to help define it as well. Thank you.
Thank you so much. A perfect way to get us started. You know, from time to time, people say, So has the court reopened yet? And I say, we never closed. Things changed, but we never closed. And we've sure learned a lot in that process. Judge Kaye, from the perspective of Lower Manhattan and 500 Pearl Street, what's your lightning round standout thought from last year's pivot to
Well,
remote?
I echo everything that Justice Ali said, and I agree that the pivot was quick. I mean, we took a deep breath in March when we went remote, and for the cases that I was supervising for general pretrial purposes, we just gave everyone an automatic 30 days, because at that point we didn't know, was it going to be 2 weeks? Was it going to be a month? And that kind of breather gave us time to get our infrastructure, both here in our micro infrastructure in chambers, as well as the court as a whole. And I think on in the outside world, it gave lawyers and law firms and legal services organizations some time to figure out, how are we going to do this? Where are we going to be? How do we get documents filed? And so it was a little bit quiet, I would say, for those first few weeks in April. And then the motions started, didn't seem to stop coming in, and we figured out ways to get them done and figured out how to conduct proceedings remotely. Most of the proceedings that I do are by telephone, but I do a number of proceedings by video as well. And both of those work very, very smoothly at this point. It's a different skill set, both in terms of acting as a judge, I think, and listening and conveying the, my rulings or asking the right questions. I think I've heard from practitioners, and Jason and I have talked about this, it's a different skill set for lawyers to be arguing virtually and figuring out a different way to convey their points. But all of that has developed over the course of the year, and I would say also has worked pretty smoothly in the federal courts as well.
What do you miss?
I just had my clerks back in chambers for the first time today since November, since before Thanksgiving. So I really missed them. We were always emailing and texting and having video calls, but it's not quite the same as when you can hang out together and have lunch together and talk about what's going on. So I really missed that. I also miss my colleagues. So we were just talking today among the magistrate judges here in the Southern District about, when do we think it'll be okay for us all to sit in the same room together and have lunch again like we used to. So those kinds of face-to-face things we definitely miss.
We have all learned that it is impossible to eat with your mask on. Justice Cohen, lightning round, what stands out for you? You're on mute, Justice Cohen. I knew I was going to get to say that sooner or later.
I know, sorry. I'm going to use my lightning minute to be a little philosophical about all this.
Please.
The obvious logistical point is, it's gotten us through the pandemic. In the early days, there was some concern we'd never move our cases again, and it clearly has done that. But I think it's a lot more than that. I think this is a watershed moment in a lot of ways. I've been thinking about analogies, and the best I can come up with is when, many of you will remember this, when email first became widely used in practicing. Yes, I'm that old. In the beginning, there was a lot of resistance. I know I said things like, I'm never going to give complex legal advice on the back of a napkin, figuratively. That was then followed quickly by grudging acceptance. If you want to keep clients, you're going to have to do it, so get on with it. And then quickly followed by, how did we ever live without it? There is, though, and this is the philosophical part, arguably now a fourth phase, even with email. And you hear a lot of arguments now that while email improved the speed of communication, it did not improve quality, and has in many ways harmed the quality of life, work life, and caused stress and distraction and alienated us from each other. If you're looking for a book on that, by the way, is a really good new book called A World Without Email by a guy named Cal Newport. Very interesting. Why is any of this relevant? We're going to talk about the details of these remote conferences, but three things are clear to me. One, they are incredibly useful, and we could not have done without it. Two, they are here to stay. There are just too many efficiencies, both for litigants and lawyers trying to make a living, to be in 6 places at once. But third, like email, if we're not careful to ensure that personal contact, training, interactions, if we're not careful that they remain important to all of us and to practicing law, we could end up with some unanticipated consequences. So I think it's a good thing, but we have to make sure we combine it with other things that are important in terms of personal interactions. So I think it's a little bit dangerous to get too enamored of it, but it's very useful.
It's such interesting points that you make, and I can hear the voice of the party who was appearing before Justice Ali and the, here to stay. Do I have to come see ya? I think a shorthand lesson that would come from your very thoughtful observations would be honestly never say never. Judge Cave was saying, oh, we used to never take a video, never take a remote deposition. I have said I'll never hear a contested big argument except in person. Never say never, right? Some really interesting views from the bench. And we do get in our bubbles. You can't have a good proceeding without lawyers. And even if it's working for us, if it's not working for the bar, it's not working. Jason, get us started with a lightning round view from the bar on what stands out from the pivot a year ago to these remote proceedings.
Sure, and thanks so much for having me again here tonight. And so I've learned that from a practitioner standpoint, it is possible, maybe not preferable, but possible to litigate a commercial case from my bedroom with my husband in the room next to me working remotely, my daughter, who was 5 years old in preschool on Zoom in the dining room, and my mother, who is now living with me because of the pandemic, watching CNN in the living room. But all kidding aside, the remote proceedings have been extremely efficient from a commercial litigation standpoint. And also, I'm very impressed with how the court has been able to quickly come up to speed with the remote platforms to keep the cases moving.
I'm so tempted to ask whether more, fewer, or the same number of cases settle in that context. And I'm just imagining what a day in the life must be like, but I'm going to hold that for the moment. Hopefully we'll have some time at the end. Liz, you're an expert in the landlord-tenant court practice and have been for the decades that we've known each other. What stands out for you? You practice in a court where so much happens in person, in the corridors, in the courtroom. What stands out for you from the pivot a year ago to remote?
I mean, certainly I miss all of that. I am a courtroom junkie. I love court so much. I love seeing people there, adversaries, judges, everybody. I do a lot of business there that has nothing to do with the case that I'm working on even. But the standout moment for me this year was a personal one when I was on trial. I had begun what's called an HP trial, which stands for housing part. It's when you go to a judge in the housing court and you ask for repairs because a condition is dangerous. I had started the trial pre-pandemic. At around the pandemic, courts closed. There was a period of time where nothing happened. Then we went back in a hybrid setting where we had some witnesses testify on a large screen while we were in the courtroom, masked and with plexiglass, et cetera. But then we eventually went to a entirely remote part of the trial. And the surreal moment for me was when I was at my desk and I had a rusty pipe, which I actually showed in the first panel.
I remember your rusty pipe.
Because I really do love in housing cases to have real evidence. I had a few pairs of moldy boots. It's a mold and leak case. I had a rusty pipe. And so I had to show this, and I felt like I was on QVC. I'm showing the pipe, everyone see the pipe, and I'm showing it. And then I had to get up from my desk and walk to the conference room while I was on the record. And I'm thinking the record is going and I'm walking to my conference room so I can show my client this pipe and he can testify about it. And I just said, this is so weird. So that was my surreal moment, that this is now what trials are. I didn't like I like formality. I like to be in court. I don't like the judge helping me with exhibits. sharing a screen for me. I don't like any of that, but I had to adjust.
And now looking back, that was clearly at the beginning of our pivot. Remember when we all thought, well, we'll be done by the summer, we'll be done by the end of the summer, we'll for sure will be done by the end of the year. See you then. Now with the benefit of a year of experience of this, how do those same feelings feel?
Well, I think there's a real concern about doing trials remotely in housing court because of due process concerns and what's at stake, which is people's homes. And the truth is that many people can't always hear. It's not always the best connection. You're talking again about people's homes and lives. And I think it is critical right now that we safeguard due process. When the eviction moratorium comes off, that court is going to get exponentially busier. And there will be pressures to short circuit some of these concerns that we have, maybe push people to trial before they're ready. I don't really know yet. But I would say that other than the trials, that the conferences in general are pretty well received. And I would love to hear what people who are tenants think about not having to come to court and miss a day at work, et cetera. And it may be actually quite beneficial. So we'll see what the data shows on that.
It's a great thought, and hopefully we'll be able to collect some of that information. There will be more work at the city bar on this topic, and I'm thinking those are good pieces of the picture. Sarah, I know you think a lot about the kind of points that Liz has just mentioned and the impact of efficiencies on all the parties, and whether the impact of an efficiency is necessarily felt equally by everyone. And maybe one party's efficient is another party's denial of fair process. What stands out for you and from last year's pivot to remote proceedings, and as you look back?
There are good points and there are bad points. Coming from a court, I practice in civil court and family court and in housing court, coming from courts where there were constant waits, lines and lines and lines of people, and forced settlements out in the hallway, and like cattle, people were smooshed together, to a point where everyone gets at least a minor amount of attention from a judge. In housing court, we used to have a saying, 2 minutes of justice. You get up there and you were told your rights, and then you were either agreeing with the stipulation or the judge was allocuting you, and then you were out of there, and you really didn't have enough time to think about what was happening. And for such a severe consequence of eviction or the termination of parental rights, at least people are getting an opportunity to be heard for more than those 2 minutes, and that their justice may be of a different quality, maybe not a better quality, but it's certainly a different kind of focus that we've gotten. And the advent of e-filing has been glorious. We fought for it for years and weren't able to get it. And look, what do you know, in a matter of months, we don't have to go to the courthouse anymore. It's a marvelous, the technology and the expansion of the right to counsel, all these things, we're going in the right direction. As you know, I do have serious reservations about the due process rights of defendants, of respondents, of all sorts of the people covered by these people's courts. But as far as conferences go, I would say that we've come a long way in just a very short period of time.
Well, that is a cup half full if I ever sipped from one, and I do regularly. It's a fact of life in bankruptcy court that we have to think of our cups, and most courts, I think, as half full as best we can. It's a and I so appreciate your point, and it's so well taken, that it's easy to look at these very overburdened courts with very long dockets, and maybe even from the standpoint of the cases that Justice Cohen might see in the commercial division, relatively speaking, smaller. It's not smaller if it's your home. It's not smaller if it's your apartment. It's not smaller if it's your family member. There's nothing bigger. And it's good to think about the things that are improvements and that we can try to define as best we can and expand on, including across the streets and corridors of our different systems. Again, one of our goals for today's conversation and looking ahead. Lorna, tell us what's your
Hi.
pivot. What's your lightning round reflection on our
So
pivot?
everyone's stolen what this is the terrible thing about going last is you have
In
to
other
come
words,
up with
I should be
something
sympathetic with a
brand
name
new.
like Stong. I was always at the end of the alphabet too, but you got me with Jen.
Um,
But I know you have things to say. And we'd love to hear them.
I want to say something that a few of our my fellow panelists spoke to was the technological pivot, and I want to kind of jump on that as well. For how long I've practiced in family and in Supreme Court, and you've heard this time and time again of this is how we always did things. Things aren't going to change. This has been the process. The fact that we could move to electronic filing on the EDDS system for family court, on NICIF for Supreme so quickly that practitioners and even litigants could get copies of their records quickly now through an email system to the records departments at the various family courts. And after cases have been electronically converted in Supreme, being able to download your entire pleadings, like this is really inspirational, but it's also really affirming. And I'm going to continue to use this as citation when people tell me in the future that like things need to move slowly, that's not the case anymore. Things can move more quickly. We can radically change our technological systems to make our court system more accessible to everyone. I'm hoping in the future that means a mass digitalization of records so that people don't have to go to, the file room or the record room and look up dusty old papers and, wait for things to be scanned, that we can access them almost immediately after they've been signed. That's for litigants and practitioners both. What has also though stood out, and this is, something that has been a little sad for me to see, is that because our court administrations are very different, how Supreme is administered versus family versus housing versus criminal, you see that there's different processes in place. And when you can see one court system doing something well, you wonder why the other court system can't catch on and do better like their, sibling court systems. And unfortunately in family, I have seen that be the court system that lags a little behind, partly because of the sheer number of cases that they're experiencing. But also that means that, for families that seek assistance in family court versus families that seek assistance in Supreme Court because they might be filing a divorce case, things are not equally accessible right now. And that's something we have to be cognizant about and address in the coming months. Because similar to housing court, when family fully reopens, you are going to see that massive influx as well.
So do you think, and I'm picking up on one of the very thoughtful questions in the Q&A, thank you to our audience. Do you think it would be a good thing if remote proceedings continued to be a big part of the picture, and maybe court systems within the state and across the state federal line could learn from the best experiences of each other? And even though none of us knew this was coming, we've had to do what we've had to do for a year, and we've learned a lot. You think there's going to be some good opportunities there? I'd like to think so.
I absolutely do. I share Sarah and Liz's concerns regarding due process, especially for hearings in the kind of cases I practice, like change of custody hearings. I would say orders of protection where people are excluded from home hearings, and also trials. But in terms of conferences, in terms of especially like pre-trial conferences or settlement conferences, return of process cases, these should really, be easily moved, in my opinion, to remote proceedings. It makes it easier on, I think, the litigants who, don't have to take a whole day off, as just as Ali mentioned, in terms of like his litigant in his courtroom, parents who have to juggle childcare obligations and school schedules, And also practitioners. I have a lot of colleagues on the 18B panels in the family courts who are running often from one part to another part. That's how they got all their cardio, as they like to tell me. But, they were really just
Get your
running
steps in.
Yes, we've all haven't met our steps in a very long time. But that's how, that was half their day was spent commuting, but inside one courthouse. And even that, is a big time drainer. And so I do think that there are certain kinds of appearances that are very ripe to be moved to remote. But it would probably be a hybrid model, which is what most people are looking at now in the post-COVID world. Even my office is considering a hybrid work from home model.
Wow. Lots to learn, a good amount to hope for there. Let's take some views from the bench now. I'd like to circle back to Justice Ali and ask you to take a little bit deeper dive into what's going well, where are the challenges, any best practices for the bar, any pet peeves you'd like to share? And if you could think about one thing that other courts could learn from the good experience in your court, what would it be? Justice Ali, let's hear from you.
Yes, thank you. I signed up to the panel for this panel. I agreed, one, because I knew we had a great moderator, right? But two, I was going to learn a lot, and boy, did I learn a lot. But I did not know something, and I'm going to expose it to everyone here. I often, as supervising judge of New York County Civil Court, I often say, now I didn't realize I would ever have this opportunity, so that's why I think it's interesting. I would often say, forget about what the court system says about the commercial division. The civil courts are the crown jewel of our court system. I often said that because I never thought I would be on a panel with a commercial division judge. And I'm looking over to my right and it's Judge Cohen. I'm like, whoops, maybe I shouldn't pick a fight with a judge who's going to outrank me. But the reason I say that is this. I've heard enough from the lawyers. And by the way, I've only been a judge for 2 years. I was a litigator for 18 years. An 18B attorney who was running around courtroom to courtroom with different sheets of paper stuck in my pockets, try to figure out where my case notes were. So when we talk about due process, and I'll get to the questions, but when we talk about lawyers being concerned about due process, and I want to make sure everyone knows this, judges are concerned about due process as well.
Maybe even more, because it's our
more.
client, right? I
Right.
always think that flag due process, that's my client.
Right. And more importantly, it's my name that's on these orders. I'm signing off on these things. So for the attorneys on the panel who I've had the honor of working with, for the folks in the virtual land, or anyone who hears this, we are in the same concern boat together. If you're worried about due process, guess who else is? Is that judge who's worried about due process as well. So there's no battle there. What there is a common understanding to get to push the meter over. The reason why I firmly believe that virtual appearances work well and are here to stay is because there's a space for it. It might not be for everything, as all of the practitioners and judges have mentioned, but it could be for something. So what's worked well, and it sort of like made me think, if it works so well now, did we always have this in our back pocket? Did we not want to introduce it before? But sometimes circumstances forces us to do certain things. So what we have now in civil court, we have I counted about 13 different specialized disciplines that you can handle about 7 different subject matters before your second cup of coffee in New York County Civil Court. And what we do is that we have a system where litigants have their cases heard in a way, because dollar amounts don't matter. I mean, it's not like a $500,000 versus 500. 500 to that one litigant is a fortune. So in civil court, we've been able to have folks come before the court and have their cases heard. We've been especially mindful of pro se litigants, right? So we're not looking to default someone. We're not looking to trample on someone's rights. Before a case goes forward, I look at make sure everyone who needs to be there is be there. It's not business as usual. We are much more thoughtful. We have always been, but this pandemic has made us feel more so that we are a court with a conscience. That before we put cases on and hear cases, we want to make sure that the folks who need to be there are there to have their day in court. So I think that what's working well is the technology, and that we should work with the technology to continue to enhance it. What's not working well? Well, it's the, what's working well is the technology. What's not working well is the technology, if that makes sense. Right. And something else I want to dispel, particularly in the civil courts, there was this real concern about a year ago about the poor pro se litigant. The pro se litigant's going to be on the short end of the stick, and lawyers are going to fare better. I got to tell you, 1 year into this, there are some pro se litigants who've mastered virtual appearances, and I have lawyers who are still struggling with virtual appearances. So there's no takeaway from there. Just because a person doesn't have a lawyer, it means nothing other than they don't have a lawyer. Whether or not they can handle the technology, sometimes they do much better. I had a conference one day where an attorney sitting in his home office proceeds to take a cigarette out of his card holder and lights the cigarette on, this was certainly no commercial division or bankruptcy case. He starts to light the cigarette. I've never once said a word to anyone other than that. That's my line. You can't smoke in the proceedings, right? You can't smoke. I've defined my line. That's it. And maybe this is one of Judge Cohn's unintended consequences, the lax behavior. And I'll get to that in terms of my pet peeve. So when we talk about the challenges, the challenges is the technology. I've had outages in my chambers when I'm hearing the proceedings, so have lawyers. If there's a way to secure sort of our connections, that could be a way to continue. We talk about due process rights. When I was in criminal court, the one thing what was always on my mind was the right of a litigant and an attorney to conference and to have that ability. Even if that meant adding time, putting someone into a different room so that they can have a chance to talk, I never balked at that. Even if the proceedings went a little bit longer, I'd rather sacrifice time than that due process right. So that was there. The pet peeves, I think people have taken virtual appearances to be not a court appearance. They've sort of lacked, they sort of, in a way, attorneys disrespected their own oath to the law. I've had more than one of folks who've come in with T-shirts. I had an attorney on a bail application, very serious case, $750,000 bail ask in a tracksuit. And I thought, I know what I was going to do, but the client needed to see something better than this. And I would hope, and my pet peeves to lawyers, that treat this like real proceeding, because it is a real proceeding. These are, you have to be respectful to yourself, first of all, and to the profession as a whole. So virtual proceedings, while it might be casual, it should not be casual. And what we've learned is that you can move high volume of cases as long as you have a good system, as long as you have a system to move it. And a saying I like very much is different strokes for different folks. Different cases will take different things. So there's no one size fits all. Maybe we will have virtual conferences, but for trials, we'll bring them back in. So you reduce the density in court. Maybe we don't need folks in court 100%. Maybe we need them at a certain amount. So there's no one set rule. So as a supervising judge, the only rule I have is that we have to be firm enough to give guidance, but soft and fair enough to adapt to the situations.
So you would see some of the things we've had to use and become more comfortable with maybe staying on, but also see a return to things like in-person proceedings for something as fundamental as a trial, maybe
Sure.
especially criminal trial.
Yes,
That makes...
or civil trial. I
goodness.
think it was Liz's line. She's a courtroom junkie. I'm a courtroom junkie. I miss those things, and I think a lot of us miss it. So maybe for trials we'll have that. In the right circumstance, maybe a trial will stay virtual. So we need to be flexible enough to keep an open mind to what we're being asked to do.
Maybe just more tools in the toolkit. That is a way I have come to think about it, I have to say. Judge Cave, perspective from the federal court. You share with us your view from the bench on what's good, what's not so good, best practices, pet peeves, something we could all learn from your experiences in your court.
Sure. I'd echo everything that Justice Ali said, a lot of the same challenges that we've faced. I also very early on had, when I started doing virtual proceedings, in particular by telephone, a lot of problems with decorum on the phone and misbehavior that people would never exhibit if we were live in the courtroom. And I took a very good suggestion from Judge Castell, and he said he called at the start of every proceeding, he introduces himself and says, "Welcome to my virtual courtroom. This is a virtual courtroom, and I expect you to comport yourself the same way that you would if we were live and in person." And so I picked up that habit, and I have found people are much, much better in terms of not talking over each other, not talking over me, And also just being clear and concise. You know, I've also learned flexibility as well. There's going to be a dog that barks in the background, somebody's mowing the lawn, those sorts of things. And you just have to roll with it and accept that those things are going to happen, and everybody needs to be a little bit more patient and understanding in these times. I would say the biggest challenge that we continue to face, we've made a lot of strides on the civil side, are criminal proceedings. Well, they have gone forward, and we have moved things through the system without skipping a beat. It is very difficult particularly for incarcerated defendants in terms of their contact and experience getting advice from their counsel. All of the defense counsel that I have seen in our court, both federal defenders and CJA panel and private defense counsel, have just done yeoman's work. It's not even a big enough word for how hard they've worked to communicate and advise their clients. But especially when you're talking about someone's liberty being an issue, there really is no substitute for face-to-face interaction and the advice and the trust that comes from having that experience. And it just, given the constraints on the facility is in terms of in-person proceedings, and there's only so many only so many spots, and you can only get them so often, that there are some defendants who, you know, have gone all the way through the course of their criminal case and have never met their counsel in person. I did a plea allocution last week from a gentleman who was incarcerated, and he was entering his plea. One of the questions I asked is, are you satisfied with the representation of your attorney? And he said, yes, but, you know, I never met her, but everything she did over the phone was wonderful. And it sort of broke my heart a little bit that, you know, here he was taking this very momentous step in his life, and while his lawyer had done everything she could to advise and communicate with him, he still had not had that kind of personal interaction over the course of this particular case, and in terms of making this additional step. So my hope is that that is one area, first of all, that may particularly improve as vaccinations become more available, both to lawyers, you know, defense lawyers generally, and also to inmates. But I think that's an area where we really do need to improve, that especially if a lot of proceedings are going to continue to be virtually, that's an area that we need to work more on. And it's certainly not for lack of trying. All of the different constituencies on the criminal side of things have been working around the clock and Herculeanly, but that's one area where we're still not going as far as I think we could.
I think it really points to another piece of the picture, and it was between the lines in so many things that have been said already. And that's that it's just a fact that one thing that is different is kind of the human interaction side, and whether it's make a case, a giant litigation, an in-person deposition, a criminal plea, it's heartbreaking. The ability of someone to see that even though the judge is about to dismiss their case, they're not dismissing them. They're dismissing a case while they respect them enormously. And I will tell you personally that I feel that loss acutely, and I miss the courtroom. I miss that aspect of being able to be in a courtroom. I miss a kind of interaction that I think can happen, especially in a multi-party kind of situation like we often have in a business bankruptcy case, when the lawyers are in the same space. The number of times that a lawyer would begin by saying, well, we're waiting for the matter to be called, and they don't mean it in a bad way, I hope. We were able to talk about this, and we think we may have a way to move forward. I think you can continue that with these other tools for a period of time. Like a bridge order can give you relief for a period of time. But if you're coming into the practice from scratch, or if you're a party, you've never been in a case before, I worry about those situations. Justice Cohen, view from the bench. What's so good? What's not so good? Can you help us solve all these problems?
Sure.
5 minutes.
I've been busily crossing out all the things I was going to say.
Oh, no, it's okay.
My two colleagues had made all the points, which I think are great ones. I start with many positives that I've seen. I think the lawyers have done a great job adapting. I think we've all had situations where we had to become, MacGyver, trying to, stitch things together where somebody can hear, but they can't see you, and somebody call them by a cell phone and turn your microphone off, and, all sorts of strange things. And it has, relationships have grown just a little bit about seeing people in their home space. And so I think it's, the relationships are good. And I think that the lawyers, including people who have been practicing a long time and people who have not, have taken to it. Originally, we all were a little hesitant, but I think people have gone all in. One thing I've found that hasn't been mentioned a lot, which I was very skeptical of, but I've done 4 bench trials, and I've been extremely pleasantly surprised. I had one that was a 2-week trial with lots of witnesses, lots of documents, people all over the place, which would have been very hard to do, which led to an interesting jurisdictional question about, who can you require to come to a New York court when they're in Timbuktu, but they're not any farther away virtually than they are anyway. But, after a day or so of the lawyers and me getting used to each other and the technology, I have to say the 2-week trial was better than a comparable 2-week trial live. Things went extremely smoothly. One thing I had not fully anticipated is, the view you get of a witness from the bench is an odd one. It's above to the side, and it's a strange thing. The witness box is designed for the jury, pretty much.
That's a fair point. It looks straight on toward I have one in my courtroom.
But the bench trial, you can, on most platforms, you can pin somebody's to be the center of the screen, and you're looking right at them. And I've personally found, not, in commercial cases, you don't have a lot of, dramatic admissions of guilt, at any point, but you can really see the witness a lot better. And, again, it's a little antiseptic because they're not sitting right next to you, but in terms of just the experience of seeing the exhibits and seeing the witness, and I take Liz's point that, having the judge be the intermediary with documents takes getting used to. But just from that one perspective, the getting the witnesses in and out, for example, and also having them not have to wait in the hallway for 6 hours for the next witness to finish, there's a lot of efficiencies. And just as the bench trials have, in my opinion, gone very well. In terms of the things that I think are, I saw one of the questions was, what are the adverse consequences that you're talking about?
Unintended consequences, yes.
One thing that I don't know if you've seen, the judges on the call, is that people tend to read their arguments more from a script, because you can, right? In court, you can't sort of sit there with your script, but you can see, and people think that you can't, but somebody you can see when they're looking at a screen and kind of reading. And I get it. But I think in terms of skills development, the antiseptic nature of a video where you can do stuff like that. And you got to be careful that doesn't become your way of learning the craft. And, it doesn't bother me like people with t-shirts, which I also have seen. But I think that's something to just be careful about. You should try to treat it as a lot of my concern goes to more junior lawyers and people who are looking for mentorship and the like, who don't, I think it's a lot easier for those of us who've been in court a lot to go to this and have it be kind of a convenient alternative. But if you haven't been to court a lot and this is your introduction to it, you're gonna have to just remember this is not the way it is. It's not this easy. It's not very clean, and you're not going to be able to read your argument.
But of course, Justice Cohen, that begs the question: what if this is the way it is? At least in some cases, I think there's the unintended consequence or or the insight or the risk
Yeah.
that I think you've described is something I worry about too, which is if you haven't already learned your craft, how can we help bench and bar, more experienced lawyers, new lawyers, how can we help bring the idea that you're in a, not just say it, but somehow make it feel real. You're in a courtroom. I know it kind of looks like the Brady Bunch, but you're in a courtroom. Own it. I want to hear your argument. And I'm going to give you a ruling. You know, it is a little different. And maybe just saying it out loud. I like the
Look, I think we all worry about, I've heard people talk, you know, the water cooler mentorship, you know, people bump into each other sort of casually in the hallway of a courthouse or in an office.
You sit in the partner's office during the call and you hear how that partner handles the event, or down the hall, the firm that you share space with. That's
right. And
you
it's
can
the
live
same
without
person,
that for a little while.
the same person, you know, may not call Liz or Jason or somebody and say, well, can we have a Zoom call to talk about my career? Well, probably you're not going to do that. But if you happen to bump into each other at the coffee machine, you know, what are you working on? And you know, I think about that kind of thing. But again, in terms of what's going well, you know, the tech concerns are the big battle, honestly. I mean, they work. I think the platforms are getting better. I won't call out any by name, but the one we started with was not very good, and the one we moved to is much better, at least in the New York court system. And I think my guess is if you give these companies enough of an incentive, which is that we're going to be doing this for a while, these products are going to improve exponentially. I think it's going to be a lot easier to have private chat rooms for settlement conferences, for conferring with your client. I think, you know, Liz may have made this point. It's still very awkward if you are defending a client, or if you're in the middle of a trial and you have to take a break, you know, you have to go to a cell phone. It's never going to be as smooth and easy. But again, my reaction is that over the course of this last year, it's a lot better than I thought it was going to be. I was pretty skeptical at first.
Let me say to my panel, not if you agree with that statement, a lot better than you would have thought it would be. I've got to say 100%.
Yeah, in terms of just raw output, you know, I hear just as many motions a week, if that's, you know, a relevant metric. I don't think things have been lagging behind because of that. And if you would ask me in March of last year, if that would be true, I would be shocked, because I thought there was a real chance that we were not coming back. So I think it, as I said when I started at the beginning, it's terrific. But I think the antiseptic nature of virtual proceedings is really, really good and really, really bad. And I think to grow as a lawyer, which I know is most of the audience here, you have to just remember that the real rough and tumble courtroom hallway stuff is an important part of growth. So enjoy it for what it is now. It's convenient. I think it's going to help lawyers earn a living, especially lawyers who have smaller practices who have to be everywhere. It's a godsend. I have a friend who's a sole practitioner and used to spend his whole day driving around Westchester from one end to the other. And now he sits in one place and can triple his output.
But what if you're just building your practice and you need to be in the corridor to get the referral? I mean, I don't know. It wasn't my practice.
That's the chasm. I
I
think
about that.
Senior lawyers love
right.
it. Junior lawyers don't.
All right. It's so hey, it's working for us. What's wrong with that? If it's working for us, I think we need to hear from the bar now. And get those views from the bar. And I'm going to flip my alphabetical list, and if it's all right, although I had told you I would be going alpha from the top. Lorna, you've touched my heart. I'm going to ask you to go first. What's going well? Where are the challenges? Any tips for us? I really mean it. Any pet peeves, including about us? I really mean it. And what would you like to see adopted across courts? You've got a lot of experience. Let's hear from you.
So, you know, I echo Liz's sentiment about being a courthouse junkie. I have marked in my calendar the first day that I got to go back to virtual court, which was May 22nd. It was actually a little earlier than most people.
What does it mean to go back to virtual court?
For me, it was the same. I got to see, you know,
Like-
it was a conference with the referee in Supreme Court. On
You mean an actual physical courtroom, courthouse?
no, it was virtual. It was a virtual.
Okay.
Yeah. So, you know, it was with an opposing counsel that I frequently come up against because we, you know, it's just the world of matrimonials. You see a lot of the same players. And we have a very good relationship. And we spent, you know, the first 20 minutes talking about COVID and our lives and how this is weird and why we hate that first platform that Judge Cohen did not quite name, but we all know what it is. And so, you know, I would say that that's one of the things I miss the most. We have had to onboard new attorneys during COVID. It has been remarkably difficult, like trying to ease them into this environment. If you think a judge is scary 30 feet away from you, wait till they're like 8 inches from your screen and you can see their face when they're yelling right at you. Had an attorney that's just graduated law school, and you're like trying really hard to, you know, chat them.
Is that more scary? Is that more scary or less scary?
It was more scary. It was more scary for them. You know, that like that up close and personal like encounter was very, you know, stressful. And you don't see, unfortunately, that beginning moment where you go in and you introduce the attorney to the judge and you say, here's, you know, someone who just joined our practice. She's got this case before you, you know, that kind of off the record, like collegial, you know, moment doesn't exist anymore. And that's a shame. They also don't get the chance to see how that judge might hear a number of cases before them, get a taste for what that judge might rule like, that yelling at you is not a personal thing. Maybe they're just yellers and this is just how passionate they are sometimes. You know, that's lost. So, you know, it has been really hard training new attorneys, helping them gain litigation confidence in this environment. By doing that, I will say personally, I've liked it because I sometimes jump in a little too much in person court. Now I'm relegated to the back channel chat where I just type what I tell them they should say. So I think that, you know, it's been, again, like it's a very different experience for senior attorneys versus junior attorneys. And, you know, how they like have adapted has been, you know, largely based on both experience and lack of experience. I will say one of my pet peeves is like a lack of uniformity at this point in terms of like, how are we going to handle entering evidence, or how are we going to handle like motions being submitted and when they should be due? You know, these courtroom rules sort of, I do understand, are not always uniform from part to part, but at least for each individual judge, they should be really like well put together, disseminated, known. When I practiced in Supreme, the judges have their part rules, you know, they're posted, they used to be posted on like chalkboard or, you know, available in a pamphlet for you to pick up when you went to your prelim conference. Now they're available online. I think all judges should have that and make it clear what their part rules are. I also will say I have somehow, I just was thinking about it, yet to have a conference with a court attorney during COVID. It seems all the judges want to do their own cases, which is nice. But, you know, some things are lost sometimes when you have a conference before a judge versus a conference before a court attorney. And I think that, you know, that is, I have one coming up, which I hope will go forward. That I've been wondering like why that has been that kind of odd anecdotal trend that I'm seeing. And I think that that could be better utilized, particularly as, you know, we get more and more cases that not, you know, a judge may not need to hear every single conference. I don't want to step on any toes there, but yeah.
It's so interesting because it points to the sort of the inverse of the idea that we've been forced to try a lot of things, many of which we've learned a whole lot from, and some of which we should hold on to. We've also, I guess, been forced to move away from some things. You know, that the judge comes out after the court attorney has conferenced some of the initial cases. I remember that from years ago in Special One, if that even still exists, and maybe I hope it doesn't. It was a good place to learn a lot about the practice of law. Maybe there are some things we need to take a closer look at. Sarah, Views from the bar. What's good, what's not so good. Tips for us, pet peeves with judges, and yes, you're allowed to say so.
Of course, with all due respect.
Yes, 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 yes. Reverence, even, I'm sure. I still have been I was a litigator for longer than I've been a judge, so I totally get that part.
I echo Lorna's concerns about supervising people. The amount of times I went to court with counsel, staff attorneys, and they just saw me work or vice versa. And I was able to give them feedback and they were able to see how it went in all different contexts. And we cannot do that now. And even if we have a link and we're up there in the corner watching the proceeding and furiously texting, so we're forcing our new people to look at the screen and focus on what the judge is saying and the litigants are saying and look down at their phone and what we're saying. And of course they have another screen, you know, if they're affluent and they're looking at documents on one screen. It's a heavy load for a young attorney and for their supervisors as well. So that's a very interesting point that has been quite a challenge during the pandemic. I think that you know already what I think is great. I think that the expansion of the right to counsel is great and e-filing is great, but we still can't get our hands on paper files at all. So what you're doing is appointing counsel for cases and then they don't have an ability to know what's happening in those cases because the paper files aren't able to be received. I also think there's a vast difference in technology aptitude between the more sophisticated courts that have more resources at their disposal and the people's courts, as you term them, and that the people that are affected by the people's courts in light of the Black Lives Matter movement are mainly people of color and they're poor and just, I would hope that there's more focus on the fact that we need dignity in these proceedings and speed in light of the Chief Judge's Excellency Initiative isn't necessarily at a premium here. That's not really what we're getting at. I know that the courts are very concerned with clearing the dockets and moving cases along and only a 2-week adjournment. But I think that it's important to realize the people that are being affected by the speed at which we are trying to go in this new format. And my recommendation for the bench in light of that is that quantity is not necessarily quality. And so when, for instance, in a civil court format, I'm told that I can only have a 2-week adjournment until a trial, that means I can't do a notice to admit during that 2-week period of time. It's a very quick turnaround. It's very hard for a legal services attorney to prepare for trial in 2 weeks when we have a full load of other cases. So if the judges, I think, in the parts that are being pushed to get cases done and to clear their dockets, would maybe do so on a case-by-case basis as opposed to I only adjourn cases for 2 weeks. That might be a good idea, as well as to understand that the parties in these cases, dignity is at a premium here. So I know that that all of the judges, of course, are in very concerns with due process and how the courtrooms are run, but just out of sheer tradition, the systemic racism that has gone on in these courts for decades prior to the pandemic make it doubly important that the litigants are focused upon now as people and not as docket numbers and cases.
Such good points and so well made. I remember, this is personal, when I first became a judge thinking not everyone's going to be happy, but at least everyone deserves to know that someone who really cared made a decision in their case. That sounds silly. It was not silly, still isn't silly to me. And they should know what happened and why. And that someone, if they don't understand that, then we're not done. I can't tell you how many situations I saw as a less as a lawyer, more as a judge, maybe, where it just was true that the slow way is the fast way. That if you want a good process and you want a process that people have confidence in, the best investment you may make is if someone tells me they need a month, they get a month. And actually, when they come back, if they told me they needed a month, if at the time they needed or said they needed, and things happen, everything takes longer these days. But powerful points and well made. It's, I think, increasingly, maybe it's always been this way, but it should be obvious, it certainly is now, that the work of the court is not measured by a metric like minutes per order or days per case, nearly as effectively as it is quality of the justice and the perception of justice. Thank you. Liz, view from the bar. What's good, what's not so good? What can we learn from your experience?
Also a big question like about clerks' involvement and how they've managed all of this. I'm just so interested to know, especially because we did go to e-filing in the course of this in the housing court. And they had to get emails for everybody and litigants, and just that must have been so difficult. So anyway, so let me now shift back to the questions, what's going well. As I said before, the conferences are going well. I would say that they're starting promptly. The feeling is that the judges are very familiar with the case. Contrast that often with the pre-pandemic, where there would be a bunch of files put in the judge's basket because there were 50 cases on the calendar and the judge was catching up. Whereas if there is a Microsoft Teams invite sent, the judge is generally up to speed at the time of the call. They know if there's a motion, an argument, a settlement, whatever. So I just want to say that there were a couple, I think people are trying to iron things out in the housing court. I had an experience in Queens the other day. I had a conference. I got an invite for 9:30. But I also got a list of cases that my case was on at 12 o'clock, but my adversary and I decided we better get on at 9:30. And then there was a guy on the Zoom, on the Teams call who we didn't even know who he was. He was from another time. And I'm saying to myself, and of course, I don't want to say like, who are you really? Like,
we say that.
I'm like,
we'll do it with the phone
guy?
number.
I'm like,
who's
who is this guy?
516?
But the other really, kind of confusing, kooky thing was, before I was representing the tenant, there was an application from Adult Protective Services for a guardian, and the guardian was coming on at 12 o'clock, but we, the lawyers, didn't remember the guardian might come on, so we went ahead and did it was just, we have to redo the whole thing, and it was chaotic because the judge was actually inviting everybody at one time, and she was covering two parts. So there was a whole lot of people, and I think this happens in Supreme, where you have, a conference part and everybody's invited en masse, and then whoever's kind of ready starts talking. Now, I don't know how that really works. I've never used a breakout room or anything like that. Important with tenants and tenants associations, people do want to join the conference. Courtrooms are open to the public. And so I remember Judge Elise mentioned, I think in our first panel, the remote option for people, or maybe there are going to be stations around the city, or there's going to be ways. And as I said, people are working on this. The court system's working on this where other people can join. And so that's going to be, I think, great. Just a couple of other points. Where do the challenges persist? I think we talked about the technical divide. Interestingly, I think there's a big tech divide among lawyers. Some people prefer Zoom. I think some litigants too, because they're doing Zoom with their kids at home, and they don't necessarily feel all that great with Teams, but I don't know for sure. Evidentiary issues. Again, doing a trial or a hearing in housing court remotely has its particular challenges, and it's not only tenants and tenants' due process rights, it's landlords as well. I mean, even represented landlords have had to, represented parties in the cases have had to adjourn because the witness doesn't have the evidence in front of them. And it makes it awkward. And the judge says, well, we got to get you the evidence in order for you to talk about it. So, delays hurt landlords, they say. So that's not so good in a trial in housing court. Don't know how good the record's going to be. Our record is it's not a court reporter, it's under the FTR system. I've gone back and listened to the tapes. Some of those have been I don't know what I'll get in a transcript. And in terms of Sarah talked about best practices for the bench. I think the important thing is due process, especially when the eviction moratorium is lifted. And I just wanted one point about evidence and to state again, housing court, there's no right of discovery in housing court. So we don't necessarily know what the evidence is going to be as litigants. There is no authority for a judge to mandate certain rules that we give over the evidence in housing court. However, many of the parts have suggested that evidence is exchanged before, and the Special Commission on the Future of the Housing Court took a step in that direction in 2018 when it made a suggestion in a pretrial conference that, among other things to be decided among the litigants, is, what are your exhibits? But the whole exhibit thing and sharing exhibits in remote is something to be looked into further.
It's funny because it's things that are taken for granted in other settings. I know it's part of my pretrial order. And everything's harder when it has to happen remotely. Jason, the first shall be last, the last shall be first. Let's hear your view from the bar about what's going well, not so well, and tips and pet peeves for courts.
Sure. So from the perspective of a commercial litigator in both the state and the federal court, I can say that what's going well are the routine court appearances, the scheduling conferences, the discovery conferences that are happening virtually. I think there's a lot of efficiency, as people on this panel have mentioned, to having those proceedings where parties are not required to appear with counsel. I think there's a lot of efficiency in terms of not having to wait in the courthouse for your case to be called before appearing, having a scheduled time to actually appear. By doing that, you're saving time and money for the client, right? You're saving the client the cost of traveling. And at the same time, the time that you're saving in traveling to the courthouse yourself, you can otherwise prepare for that conference. I think what in turn that has created is more cooperation amongst counsel. I find that most of my adversaries are reaching out, or I'm reaching out in advance of the conference to discuss dates for discovery and the like.
Is that happening more than it used to, do you think?
I think so. I think, especially in state court proceedings, counsel used to wait to do it when they got to the courthouse. They would, sit in the courtroom and fill out the preliminary conference order and choose their dates there. So now people are getting on the phone beforehand and they're trying to work these things out. And that in turn creates the ability to have settlement discussions earlier as well. So the communication, I think, between counsel has increased as a result of the virtual proceedings. And although, I don't know how long that's going to last, right? Once people start figuring out how to use the platforms more easily and the technology gets a little better, people may be a little more reluctant to reach out to each other. I think the lack of understanding has inspired people to, come together sooner rather than later. Separately, I think in terms of, not separately, but where do the challenges persist? I think, again, reliable technology. What I fear most is not articulating my argument to the court. It's my screen freezing. I'm always paranoid. I'm not presently in New York City, where my internet connection is fantastic. I'm out in Southold in Eastern Long Island, where oftentimes my internet connection is extremely spotty. So I'm always nervous about freezing and what do I do if I freeze. I also think understanding what processes are available and permissible to do things that otherwise would be done in person remotely. I think Liz touched upon this in terms of the presentation of exhibits. What methods are available to present exhibits to witnesses virtually? You hear a lot of you hear a lot of people thinking about how to properly present evidence in cross-examination, right? Where you may not want to give the witness a heads up as to what exhibits you may show him or her during the cross-examination. I have never had a virtual bench trial, but I've spoken to several lawyers who have had virtual bench trials, and cross-examination seems to be the biggest issue that they have had. The thought is that you don't have the same flavor of cross-examination virtually that you have in person. And so how can we improve the technology, or will the technology be improved to be able to do that, to have that same experience on cross-examination? Tips on best practices for the bench. I think judges should continue to set forth guidelines for how they expect the virtual proceedings to be conducted in their virtual courtrooms. I think it's helpful, and I think also that the judges should either mandate or provide some type of technology testing prior to the virtual hearing or the virtual conference, whether it's a clerk or someone at the courthouse who counsel or litigants can otherwise call and practice, do a dry run of the use of the technology. I think that could be helpful. And what practices would I like to see adopted more generally across chambers and courts? I love the state court sending out the calendar invites with Microsoft Team links. I think that's super helpful. From the folks who I've spoken to who have had virtual bench trials, the sense is that they've all outsourced the virtual platform to a centralized coordinator, such as trial graphics, for instance, who would coordinate the actual virtual proceeding. That outsourced party would allow people in and out of the proceedings, would set up the breakout rooms. They would also host the actual virtual session. I think if the courts can somehow figure out how to adopt a centralized system like that, I think that would be helpful rather than having the parties do it themselves. And one thing that I think is going well, and I think should continue post-pandemic, is permitting the public to continue to have access to proceedings telephonically. I don't think it's necessary anymore to have people who want to listen into a proceeding come to the courthouse to do that. I think that having access telephonically has allowed more people to listen into what's going on in the courtrooms.
It certainly should. Most people have a phone. It's something I think we need to continue to focus on in our remote proceedings, because public access to court proceedings is foundational to independent courts, access to justice, learning your craft as a lawyer. There's a very thoughtful question in the Q&A about, is it possible to sit in? Let's say you've got a big argument in front of Justice Cohen. You want to see, what's it like to be in his courtroom? I used to go day before, a couple hours before, just to get a feel, and it's harder to do that. Thank you for those views from the bar.
Judge Stong, if I could just mention one more thing, which I don't believe has been mentioned yet, in terms of what challenges persist.
Yes.
And that's the virtual jury trial. Not aware of any virtual jury trials in the state of New York, and whether or not that will happen is an interesting question.
I received a jury summons, a jury questionnaire for King Supreme a couple of weeks ago, and I filled it out and sent it in, and we'll see. I'll stay tuned. But I don't know, and we have about 15 minutes left for our discussion questions. Everyone keep that one in mind. Also the question about public access, professional access, if it's not your matter, so that we make sure that justice in our court systems doesn't somehow become a little more transactional than it should be. But I'd like to circle back to Justice Lee and ask him to tell us from the perspective of his court, more than a dozen judges, thousands of cases, my guess is thousands and thousands of cases. How do you think about the very important issues that were identified by everyone, but in particular by Sarah when she talked about the quality of the process, the quality of the perception of the process, the importance of respecting of the dignity of all the participants in the process. You're a leader in your court. How do you think about that in your courtroom and in your court system?
There is great value to hearing. I absolutely enjoyed the perspective from the bench, and there's absolute value from the perspective of the bar, because it sort of keeps us honest, right? Even if we all shake our heads and say, yeah, of course, that's what we're doing, it's good to hear it. So from all of the practitioners, you hit all the high points, and I have a growing list of things I want to say. Jason nailed one point at the end, something that the practitioners and judges, we sort of forget in this new world, but like when we have a 30-minute block of time per case, that is selfish time. That's your time. It's not shared with anyone else. There's no other case. So I have practitioners who come to me unprepared, and I'm like, we have half an hour and you're not prepared. I'm focused on just you. So one of the unintended consequences, going back to Justice Cohen's point about the unintended consequences of in-person appearances, the old way of doing business, was that we always knew when we were in person, we can pick things up and sort of like solve problems very quickly. We can't do that now. So it trains litigators to be more prepared, but here's a news flash. It trains judges to become more prepared as well. I'm reading over all of my cases now ahead of time because I have that access. I have the arguments ready because I have it ready to go. So it turns out everyone's more prepared. Okay, access to justice and dignity. Again,
Yeah.
we are on the same page there. The dignity of the court and the process is a reflection on the litigants, reflection of lawyers, but reflection of judges, of all of us, the administration of justice. Access to justice, we've never once in civil court closed our doors, not during the pandemic. If you all remember a couple of months ago, we had that major snowstorm, and in New York City, a major snowstorm was what, 4 inches? But I think this was even like 12
Maybe
inches?
6.
Maybe 6. Our doors stayed open. We debated. I was on more calls than I thought I would ever be in my life about a snowstorm. And we kept the doors open. And I kept track of the users coming in. 2 individuals came into the courthouse for, ironically, name changes. But we kept that door open. We never once locked the doors. We never denied access. In this current system, it's not an all or nothing. If someone comes in for an emergency application, say an illegal lockout or freezing of an account, that person gets to see a judge that day, whether it's totally remote, whether it's a hybrid, one person in the courtroom, one person appearing remotely, or both individuals appearing. The court system has such a different playbook now. We've been forced to open up our playbook with one thing in mind: access, justice denied is justice not served. And I'm sure I butchered that quote altogether. So if someone
Delayed and denied, I think.
Thank you, Madam Moderator. Thank you. So we keep that in mind. And about the dignity, I supervise a courthouse. I look at the numbers. There is no special medal or merit for a judge who moves cases fast or not thoughtful. We don't get paid by the case or dispositions. I want to see thoughtful dispositions, not just pure numbers. So to Sarah's point, it's not about the numbers. I agree with you. It's not about the numbers. I want to see thoughtful dispositions.
But let me ask you a question about that.
Sure.
If there was a judge whose cases were moving half as fast as the average, you might become aware of that from the standpoint of case administration.
Sure.
But what if it turned out that every single person that left that judge's courtroom felt good even if they lost?
Right.
There's people saying, man, they're behind. I guess
Right.
as a judge, you worry. You're more likely to hear that than you are to hear, boy, people are just, if you're the judge, they're relieved because they know win or lose, at least their client's going to know they got a fair shake. I mean, hopefully every judge would inspire that thought. But
I was a public
really?
defender, right? I was a public defender for over a decade.
Okay,
And
so you've
when
got
I
a good
started-
perspective on this.
When I started as a public defender, I learned so much. And the first thing I learned was that I thought clients wanted an outcome. And the clients taught me. They said, we don't want an outcome. And this is what I teach my judges. We want a fair shot, because I know I have a good case. And if I have a judge who will hear me out, I think I'm going to win. And clients know one person wins, one person doesn't, and they can appeal or do whatever they want with it. And they leave as long as they feel like they've been honored and that they've been heard and that it was fair. They think they're happy. And the thing I teach my judges is that you don't have to worry about whether someone's happy or not. Give everyone a fair shot. Have the dignity in the process. And that is in person or virtual. As long as our core values remain the same, it doesn't matter what the medium is.
All right. We have about 10 minutes left, and I think it may be one of those things where they literally pull the plug on us when our time is done. So I first thank you, and thank you all. Let's move through. We're going to do slightly lightning round mode on our discussion question, and I'll remind you that our last discussion question is going to be, how are we doing on access to justice? And in that, I'd like you to have in mind one of the questions I see in the Q&A, which is pro se's. Is there anything more to say or think about pro se's? We've heard some pretty encouraging stuff. Sometimes the experience is not so good. But in lightning round mode, my friends, we'll start with Jason. And is it important to have standard procedures from judge to judge and court to court? What about that judicial independence thing? Who's going to make them do it, even if the answer is yes? How important is that anyway?
I think it's very important to have a baseline. Look, I don't think there needs to be total uniformity, but I do think there needs to be some basic principles that are applied uniformly. And I think that it's necessary for three reasons. First, it allows the litigants to better prepare for the proceeding. Second, it allows litigants to invest in the necessary technology to be able to participate effectively in the proceeding. And fourth, it allows litigants to refine their practices and their approach to the virtual proceeding.
Makes sense to me. And I like the idea of the baseline. It's different when you're the judge to have different lawyers. It's different when you're the lawyer to have different judges and to be in different courts. Although I hope that one thing you're seeing, I say this to our fabulous participants and our fabulous panelists, we have so much more in common than not across all our different court systems. We've got so much to learn from each other's experiences, and like it or not, we all got thrown into the deep end of the pool about a year and a week ago. I'd like to lightning round go to Liz Donahue. Pros and cons of telephonic and video proceedings. What do you think? It sounds like most proceedings are telephonic. Some proceedings are video. Is that not, if you agree? That's certainly my experience in my courtroom. The pros and cons, Liz.
Video only is my experience. Early on in the pandemic, there were a couple of phones and it would not go well. It's only because the video went poorly, and so it was the default. Yeah, I think federal court maybe is more telephone only, but I don't know. But so the proceedings, I mean, the video, you know, I'll just give you this one quick funny experience I had on my trial. I had a witness. It was an important part of my case. He was a rebuttal witness. I got a document entered into evidence. It was up on the screen. I didn't realize that my adversary was frozen, and I am going to town on this examination. I'm saying to myself, God, I am getting this stuff in. I have no objections. I'm so excited. I'm going. And then all of a sudden I hear the judge say, Ms. Donahue, your adversary's frozen. And then he gets unfrozen, moves to strike my entire, testimony. And I had to start all over again. And I was insane. But yeah, that happens.
We do have a whole new lingo. I think this could be an interesting column in 44th Street Notes. You're on mute, your adversary is frozen. I hope that was never said before, we'll say March 15th of 2020. I'm gonna use one of my favorite acronyms now and put a question lightning round to Justice Cohen. How does ADR fit into all this? And I'd like to hear from others as well. But Justice Cohen, let's start with you.
Yeah, I mean, it's still very active. You hear views all over.
More or less the same?
Our numbers
Different?
in our particular court, our numbers were up 2020 over 2019 in terms of people who use the court system to arrange mediators for them. The anecdotal evidence is that the success rate is about the same. Interesting, some people say, well, it's great because it's really easy to get to and, do. And I've heard other people say it's bad because it's easy to leave. Meaning that, if you force everybody to fly into New York and, then they're not going to walk away that easily, but it's pretty easy to hang up. And it's a little more complicated to do breakout rooms and whatever. That's a function of the technology. But my personal experience, I've been able to make it work. You have to do it. It's a little more awkward. But the numbers are pretty good. We don't have time for it, but at some point, the civil court is experimenting with a really interesting new technology, the online dispute resolution, which is a fascinating piece of software, and that I've been thinking a lot about whether it, has applications in all sorts of cases. It's too much to get into in the 4 minutes we have left, but at some point, it may be worth people hearing about.
It sounds like that's probably a topic for for its own program. Well, as promised, but we'll spend just a moment on video because, of course, we're being very careful not to address any particular platforms. But it does sound like there are some tools that are useful. I'll say from my own experience, when I've had video hearings, I'm getting more and more comfortable with, and I mean technically and case management wise, with saying I'm now going to direct you into the conference room. It used to be off to the side in the courtroom. Didn't need to leave the well of the court. Now it's a virtual thing. I'm leaving. We're stopping the recording. We're turning off the video. We're turning off the audio. And you'll communicate with my courtroom deputy when you want to come back on the record. But it's going to make a lot of sense for you to speak for at least 5 minutes, I think, maybe more than that. What are some, so that's a pretty basic functionality. What are some features, even if we're not going to name names, that you especially like and have found useful in the different video platforms? Raise your hand if you'd like to jump in on this. If anything I know from my experience, I've already shared. So
pinning is really good.
Pinning, what's pinning?
You can personalize your screen. Instead of looking at the gallery the way it just sets up, you can say witness, questioner, cross-examiner, and your whole screen will be those three.
Liz, your experience has been predominantly video, you said. What's a feature that you found especially helpful? Besides being off mute. You're still on mute. Oh boy, here comes.
Okay, here we go. Sorry. I think sharing the screen and being able to do your own exhibits so that the judge doesn't have to scroll down for you. Woo, I don't like that. Thank you. I like to do my own exhibits.
Thank you very much. What about techniques to be sure nobody's cheating? Even, we understand viscerally what you can do and what you can't do, but I can think of clients I had, 20 years ago who would have thought, well, if I'm stuck, can't I just text you a question? You're my lawyer, right? The answer is no, you can't. But what kinds of, are you concerned about that? Is that kind of a hypothetical concern? I see nodding.
No, I think people text. I think people are texting. What they're texting about, I don't know. And we used to say that question, did you have a conversation with your attorney in between your direct and your cross-examination, Mr. Witness? No, but they could have been texting. I mean, anyway.
I put it in terms of communications. I just say all communications have to be on the record of the hearing. So you can certainly have them, but they're going to be on the record of the hearing. Waiver issue, maybe if it's attorney-client. Lorna, any thoughts on this? I think I saw your.
Yeah. So I mean, this might have been a very small local news kind of segment, but I represent almost entirely domestic violence survivors. So amongst my kind of circle of colleagues, everyone sent it to me. And there was a case, I believe it was out of Michigan, in a criminal proceeding a few weeks ago, where the prosecutor, in the middle of her examination of the witness / complainant, had a suspicion that perhaps the defendant was in the home, against whom an order of protection was issued. And it turns out he was. She had police go to the home to double check. The judge asked him to step out of his home, which he gave a different false address to confirm where he was. And it turned, he ended up leaving the screen for a moment. She ended up leaving the screen for a moment. They came back. The police were there. And yes, he was in the home in violation of an order of protection. This is something that, amongst my clients is certainly something that we, are concerned about because of COVID concerns, because of economic strains. A lot of the time we have been seeing during COVID, there's been reunifications, people coming back into the home, leaving the home despite orders of protection being in place. There could also be third parties, in-laws, friends, community members, who, have been influencing our clients or, people who have been reporting incidents of family violence or domestic violence. And that's certainly something that we have been concerned about, whether or not, our clients are alone in their homes when they're speaking to us, whether they're alone in their homes when they're on the available for a call. Another concern is who's watching the kids at a time the court proceeding is going on. With young children, of a certain age, and with COVID, you can't really expect a custodial parent to step into another room for 30 minutes or an hour to be on a case, while their 3-year-old or 2-year-old, is in another room, or maybe even a 6 or 7-year-old. What happens when that child runs into the room for mom or dad? And you're talking about really sensitive custodial issues, So these are, some real world kind of concerns to be cognizant about, but also in a way to try to build around. Those things can happen, like if we're operating from home, things like that will come up. It shouldn't be the fault of the parent, when something like that comes up and he or she may need to step out to deal with a childcare issue, like in the middle of the proceeding, because that's kind of the reality we're living in. But as to the others, just like a judge can, say at the beginning, this is a real virtual trial, this is, virtual courtroom, there can be, that 30 seconds or a minute to confirm, can you turn your camera and show that there's no one else in the home? Can you tell me, if it's not a confidential address, where you're testifying from, and if there's any other people, in the home that you've discussed the case with, or things like that. I think those check-ins are important for litigants, witnesses to remember the seriousness of the proceedings that they're, participating in.
And maybe it circles back to the points about the dignity of the process, and that can span the range from the points you've just made to the T-shirts from the lawyers, which we don't tend to see much. And when we do, we're really not sure what to do about it. Just tell everyone, remember it's a court hearing. I haven't yet imposed a dress code, even when people are physically in the courtroom, but it can be a bigger issue than that too, I think. Access to justice, I promised you I was going to end with that, because we begin with that every day we go to work, whether we're doing it on the phone, doing it on video, doing it from our kitchens, doing it from our chambers or our courtrooms. It's kind of the point, actually. And I would invite your final comments on that, and then I'll just give you a quick heads up on where this project is headed. But I'll let me just go in the order that I have people on my screen. I'll do it that way, which means Justice Cohen, I'm back to you. Access to justice. Any parting thoughts? It's the big one. You're on mute.
I think what everybody said, it's easier to get to court this way. But I'm probably not.
And that's got to be a good thing. At least we
yeah.
should try to embrace that as a good thing. Jason, access to justice.
So Judge Ali, in the beginning of the conversation, had mentioned that pro se litigants have not had as much difficult as maybe the bar had anticipated, and I find that to be comforting.
I do too. My concern is this: the ones that are having difficulty are the ones we don't hear. And so you're going to know when they're not having difficulty, because boy, you know it, because they're filing, because they're showing up. But I always worry about the one you don't hear from. Lorna, access to justice.
Actually, that's exactly the point I was really going to touch upon. The firstly being that once you're in the court system, once you're litigating, I think this virtual technology has made it a little easier, particularly for litigants who are juggling jobs and childcare and other, elder care and other concerns. Even the commute on the subway can be horrendous at times. But, there is a huge issue with getting to court at this point, with filing documents. And there's a huge issue with also language access. There's a digital, I think, technological divide amongst those that, are in a position economically to be able to have reliable Wi-Fi, have reliable technology, have laptops, computers, things like that. be of a certain age, of a certain education, to be able to navigate those things. I mean, I personally had to help, my parents through navigate like the unemployment website, which in Florida was just, I can't even, it made me cry at moments. But at the other end, you also have just a basic like English not being the first language of a majority of New York City residents. And that the fact is that most of the materials, notices, information available out there is predominantly in English. And that is a huge issue in terms of access.
And hopefully technology tools can help us with that. I would think they
Yes.
could be able to. Sarah, access to justice. Any thoughts to share?
I think that the access to justice generally, which can be obtained in a judicial conference, has been good, depending on the technological ability of our clients and the litigants. I would say that that is one of those things that should stay. A virtual conference has been better than spending your whole day in court and having to schedule childcare and missing a day of work for the litigants that populate the courts that we practice in. However, I think that we would be doing a disservice if we were to continue trials in that setting, in the virtual setting, for people in criminal court, family court, housing court, where the consequences are so dire, and not be able to have a full display of proper evidence, and having to look at everything online and not seeing any originals or be able to poke holes in anything. So I can't in good conscience endorse remote trials. How's that?
Even Liz's pipe, it's a pretty good story. Liz, access to justice. Thank you, Sarah. Over to Liz.
I agree with Sarah 100%. I think the good news I heard was that housing court judges are going to assign counsel to any pro se. Sarah, maybe you know that, to any pro se litigant. I mean, we know the right to counsel has expanded. It is expanding. That is great. And thank you to the court system for that. And it will expand further.
Judge Cave.
I think the biggest thing I've learned and that I will see going forward is what a team effort it is. It requires not just the intervention of the court, and it's not just focused on the pro se litigant or the lower income litigant, but it really requires both sides. We have relied quite a bit on defense counsel, where the plaintiff is pro se, to help us with access and communications and things like that. And so I think it's the holistic team effort that has been very important and is part of the success that we've been able to see and will be part of the process going forward. And I apologize, I have a urgent criminal matter that came up that I have to handle remotely.
And you're done. We'll be done in a minute.
So
And
good evening,
this is the
everyone.
life of a judge, right? Justice Ali, you can bring us home. Access to justice.
Access to justice. To Jason's point, I make it a point to sit in the pro se part once a week to make sure that I know what's happening. So when I make the statement that pro se litigants are signing on a regular basis, it's with full knowledge. And not only do I sit in there weekly, I assign my judges to that part on a regular basis, so they know as well. The court system is set up for multifaceted approach. One, we'll take the cases virtually if we have to. When folks cannot sign on virtually, they come to the courthouse. That's the behavior. And not only that, we actively send out notices on pending inventory to get people to contact us. So as a supervising judge, I want this to be very clear. If I had a choice between hearing a case where I was not confident that we had everyone, or putting that case back in the shelf and wait till we can get everyone, we're not moving on that case. There's nothing anyone will ever say to me about numbers to make me trample on anyone's rights. And that's just the way it is. And that's just not New York County Civil Court. That's levels higher than me and our court system. Our chief judge has charged us all to reimagine litigation. This is the world of reimagining litigation.
Yeah, and a perfect note on which to end. And I think it would be perhaps not only state courts all across the spectrum, but your federal brothers and sisters across the street or across the river as well. That's just what we do. That is the product. There is no metric. There's no standard or goal that is a higher standard or goal than access to justice and being sure that we are delivering it each and every day. My friends, each and all of you, you're my old friends, you're my new friends, you're my heroes tonight. Thank you so much for the work you are doing and you will continue to do. Thank you to our fabulous participants who have joined us this evening as well. And we're in now 11 minutes of overtime. So we're going to declare victory. But we're also going to declare that this is a work in progress and we need all hands on deck because we've been forced to get real smart about a lot of things we thought we'd never, ever do. We're going to put the word never in a box on the highest shelf and get to work to be sure that we're meeting that access to justice. Thank you so much. Thank you for joining us. Goodbye, my friends. And stay tuned because we are not done with this project yet. But we are done with this program. Good night.
Thank you all. Great job moderating. Thank you all,
Great.
panelists.
Great to
All right,
see
back at
everybody.
you. Thank you so much.